May it please the court. Members of the court, my name is Jervis West, and I represent the appellant Israel Delgado. And before I begin, I'd like to reserve 5 minutes for rebuttal.
All right.
And members of the court, unless the court would like me to address a specific issue first, I would start with the first issue and go in the order listed in the briefs. The first error that the trial court made in this case was to admit the child hearsay statements. I believe they were a critical portion of the state's case.
Would you do me a favor? Would you talk into the mic a little bit more?
Yes. The error that the trial court made in admitting those statements was essentially employing the wrong analysis. Under the Townsend case, the Florida Supreme Court made clear that this is evidence that must, before it can be admitted, it must have clear indications of reliability. And they even used the phrase, it must be clearly reliable.
I'm with Judge Valenti. I need it just a little louder.
Oh, I'm sorry. In the Townsend case, the Florida Supreme Court made clear that before child hearsay can be admitted, a trial court must find that it's clearly reliable. And given also that it's hearsay, it comes to the court with a presumption that it's not admissible. And that the evidence code clearly states as such. And that makes it very different than, for instance, the evidence in issue 2. So in this case, the trial court essentially viewed this as a presumption that the evidence would be admissible. And the court essentially recognized that there were indications of reliability throughout the statements.
Did you run a motion in limine first, test the admissibility before the judge had to rule on this during the trial?
No, Your Honor. It was, I was not the trial attorney, but I'm about 99% sure that it was raised beforehand. It was raised beforehand.
In limine or just
in limine, it was, I believe it was even a couple of months before the trial started. And I can double check.
Motion to use child hearsay, kind of one of those things you have a hearing on it.
Exactly, and
It has to stand alone.
it was, and if I recall, I don't know if the judge entered a written order, but I know gave a pretty lengthy oral order at least. And I believe, thinking back, that it may have been the state's motion. I believe the state may have had the onus to file that motion and address it before the trial. But it was addressed before the trial. And the trial court gave a pretty lengthy analysis of the statement. But again, the problem with the court's analysis is it's recognizing all these points where, yeah, there are questions about the reliability, but the court finds on the whole that it's not entirely unreliable. And the problem is that goes against Townsend and the presumption against the admissibility of hearsay. The court noted at several points that there were times when the girl making the statement doesn't give clear answers, essentially goes off on tangents, can't provide details. And the court, instead of following Townsend and finding that, yeah, these are indications this is not clearly reliable, essentially says, it appears that there's some questions, but it's not entirely unreliable. And the court essentially flipped the Townsend analysis on its head and made a finding that despite all of these many indications that raise questions as to the reliability of the child making the statement. Again, 15, not a young, particularly young child, a child that you would expect would be able to relay these various details, especially given her accusations of how many times these acts occur. So in any event, I would suggest that the court's analysis in admitting that statement was flawed to begin with, and when we look at the whole facts of the statement, the totality of the circumstances, it would not be admissible under the child hearsay exception. And the Hire case, which we rely on, I know the state pointed out, was not necessarily a case where the court found that the statement was inadmissible, but found that the court did not follow the proper procedures in admitting it. But I think what's important in Hire is the court noted that there were clear indications of unreliability, or at least there were indications that made it highly questionable. And I would suggest the facts in Hire are remarkably similar to the facts at issue here. And if comparing the facts that the court addressed in Hire, I think clearly shows that any reasonable jurist following Townsend properly would see that the statement was not reliable. And moving on to the second issue, which is the admission of the collateral acts testimony.
Can I ask you a question?
Yes, sir.
You're talking about other factors that the court may consider. My question is, under the case law, the court may consider these other factors, but is not required to consider those other factors? Is that true or false?
As under my understanding of Townsend in the case law, there's a non-exhaustive list of factors that the court may consider. But I don't know that there's, I think it's probably in the court's discretion to weigh various factors and then potentially assign them different
Well,
weight.
one factor could be worth 5 other factors. Just like a death case.
I agree, it could be. But I think going back to the Townsend holding that it must be clearly reliable makes this very different than a situation, for instance, in the issue I'm about to get into, where there's a presumption that it would be admissible. That's not the case with the child hearsay. And I would suggest that a proper weighing of the factors would indicate that it was not reliable, sufficiently reliable to be admissible. As to the second issue, this goes back to somewhat similar analysis, but based on factors that the Florida Supreme Court set out in McLean, would suggest that a weighing of those factors in consideration of the most pertinent of those factors, which I would suggest would be the closeness in time of the collateral allegations and the presence or lack of intervening circumstances. Consideration of those factors indicates that the trial court erred in admitting that collateral acts evidence, which was also very critical to the state's case. These allegations that were admitted as collateral acts happened 2 decades prior. They were never reported. I don't believe there was never any explanation as to why these acts were reported. And the reporting comes up when the prior alleged victim's daughter is now making allegations. And they're being questioned by other family members. So clearly the mother has an incentive to fabricate this, especially after all these years. And I would suggest the most critical intervening circumstance
That was
really.
the part of your argument I didn't really understand. Why does the mom have an incentive to fabricate allegations? I
Just couldn't connect the dots based upon what your briefing said.
Yes, Your Honor. So the JT makes these allegations first to her mother, and then there are a series of family meetings. This is a very close-knit family. And then, in fact, several of the family members actually live on the same property. So they have a series of meetings, and several family members are questioning what JT is claiming. They're questioning the reliability or the veracity of what she's alleging. And that's when the mother, by my reading of the record, essentially steps in out of the blue and says, hey, this happened to me too 20 years ago. Never told anyone about this, but she steps in and first makes these allegations when people are questioning what her daughter is claiming. So I would suggest that's the motive for her to fabricate this, to try to back up her daughter when others are questioning what she's actually saying, what the daughter is saying.
Okay.
The other, I would suggest, most critical intervening factor that was before the trial court that suggests why this was unreliable and why it should not have been admitted is the mother allowed JT to essentially go to Mr. Delgado's house every day for years. They would go on vacations together without her. I mean, the mother is alleging these things happened to her many years before, but yet she would let her daughter be alone with the person who allegedly did these things time and time again for years. I would suggest that is a critical intervening circumstance that the trial court did not properly weigh, did not take into account. And I would suggest the consideration of that
Is
fact.
that an intervening circumstance, though, as the case law?
Well-
My understanding of what the case law finds as intervening circumstance is, for example, the allegation comes up, there's a nasty divorce, right? And so now, yeah, there's all sorts of incentives and motives that can come into question, and it's a big life change, and people can legitimately question, hey, is this just being fabricated? I'm not following how what you're suggesting here would be an intervening circumstance.
I understand, Your Honor, and really it may be even more of the lack of intervening circumstances, but that's one of the factors, presence or lack of intervening. But even however it may be viewed, I don't think McLean, similar to the child hearsay analysis, it does not limit the court to considering only the 4 factors listed. So even if it arguably does not qualify as an intervening factor or a lack of intervening factor, I think it's a critical circumstance that must be taken into account because it just, quite frankly, makes no sense that the mother would have allowed her daughter to have this much contact for all these many years if what she's claiming really happened. So for those reasons, again, I would suggest that the trial court erred in admitting that pretty critical evidence. And I think that had it not been for that, the outcome of the case very likely would have been different. Moving on to the third issue that we've raised in the brief, which goes back to the one allegation involving the alleged victim, MB. This is a situation that I would suggest is somewhat unusual, but the state, for reasons I think unexplained, did not charge a material element of that allegation in the information. With regards to the charges involving JT, they included the lewd or lascivious language. With regards to MB, that's not there, it's absent. And under Figueroa, which this court decided several years back, this is a situation where even though this wasn't raised in the trial court, this is a fundamental flaw that did not charge a crime.
The title of the count that said lewd and lascivious, and it cites the statute.
It does.
I mean, maybe the reason why there's no argument below about this is because the defendant had sufficient notice that that count was charging him with that violation of that statute, right?
Well, he had a very experienced attorney. I would certainly hope that she was aware, but I think the big problem is, and what makes this situation different than, for instance, the Huckabee case or the Williams case that the state relies on, is that if we look at the body of the information, it does not charge a crime whatsoever. It charges intentionally touching the breasts. That's not a crime. It can be, certainly, if it's done in a lewd and lascivious manner, but that's something that can happen by first responders, parents. Many people can have reason to conduct such touching, or it can even be incidental. What makes it a crime is when it's committed in a lewd or lascivious manner, and that wasn't charged. And I would suggest if it's enough to merely cite the statute, then it makes charging documents fewer. Because
Well, and also the title of lascivious, I mean, it's in the title of the count.
it is, but the actual acts that make up the charge are not there. And if we look at what they're alleging, the acts, it's not a crime. And that's, again, what I think makes this very different than, for instance, Huckabee. The discrepancy was there was a change in the statute, I believe. And when it was charged, this was, I believe, DUI manslaughter involving an unborn child. There was a change, and at one point the statute criminalized the death of an unborn child, and then it changed the wording to viable fetus. So the discrepancy there was they used the wrong wording because of the change in the statute. But clearly, it was a crime, and they alleged the elements of the crime at the time that the statute would have been in effect. Williams, similarly, it's a discrepancy between charging an attempted burglary and a completed burglary. Clearly, both are crimes, and the court noted in both of those cases, crimes are charged in the information. In this case, what's charged is not actually a crime. And given, in addition, the fact that it charges an unspecified date over a 2-year period, I believe Mr. Delgado was prejudiced, but more importantly, he's charged with something that would not be criminal. And for those reasons, I would suggest that the trial court wasn't presented with the issue, but it was an issue of fundamental error because, as in Figueroa, there's a material element that's missing, and what is charged is not a crime at all. And finally, as to the fourth element, I recognize that the state, the standard review is in the state's favor. I would suggest, given that the evidence is viewed in the light most favorable to the state, I also recognize, as the state points out, that trial counsel was somewhat specific in the counts that she was making the judgment of acquittal for. But I would suggest, based on the totality of the evidence, that no reasonable juror could have found that Mr. Delgado committed these crimes. I think that, again, going back to the time that passed, the unspecific nature of the allegations that were made by JT, and again, bringing in the collateral acts evidence that had transpired 2 decades prior and never been reported, and from a mother who allowed her child to continue to spend time with Mr. Delgado over and over again. So for those reasons, I would suggest this is that unusual situation where the facts would not support a guilty verdict in any event. Thank you.
That was excellent timing.
That doesn't happen.
You did it right at like 14 minutes, 30 seconds.
Thank you.
Counsel.
Good morning. May it please the court, counsel. My name's Kirsten Jensen on behalf of Appellee State of Florida. Unless the court has any questions, I will just go ahead and address each issue in the manner that Mr. Wise brought them up. In issue 1, appellant argues that the trial court abused its discretion by admitting the statements JT made to the CPT interviewer. The court properly recognized that when doing this type of analysis, the focus is on the person to whom the statement is made, the CPT interviewer, and the manner in which the statement was made. The focus of most of appellant's arguments is that none of these women are to be believed. At this point, and as we all know, credibility is for the jury to decide. At this point in the game, which was brought, if it's not clear, this was brought forward to the court by the state's notice of its intent to use the child hearsay statement, and that's when they had the hearing on it. The court properly went through all of the factors in determining whether or not this was admissible under 90.80323. The court did point out that the child's statements that she did say probably, but the court also explained why, in its opinion, that this did not render the statements unreliable or inadmissible. This is a series of sexual abuse that happened between the times of 7 and 13. And no, the child could not remember specifically every single thing, every date, and what specifically would happen on that date. But that's not unreasonable when abuse is occurring over several years. The CPT interviewer explained that each child is different, that there is no ordinary way for a child to behave under these situations. Each child is different. The court's findings were not similar to, this case is not analogous to Heyer. Heyer did not deal with whether or not the statements were reliable. In that case, the trial court just failed to do any analysis at all. That's not what we have here. Under Townsend, the court did exactly what it was supposed to do. This cannot be considered an abuse of discretion. As far as the collateral crimes evidence, under 90.4042B, the defendant's commission of other crimes, wrongs, or acts of child molestation are admissible, and they can be admitted to corroborate the victim's testimony. And this case is very similar to McLean. In fact, this case is even more compelling than McLean. And where in McLean, it was not a familial situation, here it is. In McLean, the incidences of sexual violence were actually different. These are the same exact types of violence that occurred. And also they are the same age. This also shows a pattern of violent behavior. So again, it can't be found that the court abused its discretion in this case. As far as issues 3 and 4, respectfully, the argument that the information is fundamentally defective, I think is a bit disingenuous. This argument was waived. It was not objected to below. And that is because Mr. Delgado knew exactly what he was being charged with. And it was alleged that he touched MB's breast in violation of the statute, lewd and lascivious molestation. And again, so he cannot prove prejudice. And then also with Issue 4, the convictions do not amount to fundamental error. Defense counsel conceded that the state presented sufficient evidence to present all counts except count 3 to the jury. The judgment of acquittal was granted on that count. And the testimony of the witnesses, that's sufficient. If the court has no other questions or any questions, I'm here.
Thank you.
Okay.
Thank you.
Thank you. And to respond to some of the state's arguments, starting first with issue 1, one of the statements that was just made was that this wasn't an issue where JT just merely forgot to remember every specific detail. I would suggest this is a far different scenario. This is a situation where even the trial court recognized she repeatedly is being asked direct questions, is giving answers such as probably, or is not answering the questions being asked, going off on tangents. And
I just have one question I wanted to ask you about the first issue. And looking at it from a perspective of harmless error, like when you review her statement and you review her testimony, if anything, even if there was an error, I find I'm having trouble seeing how it was harmful, because to me, if anything, it undermined her credibility. I don't find that it was very helpful to her.
in some ways, it could have undermined her credibility, and it's hard to say what the jury relied on, but it's a pretty critical statement that's coming in from a child victim years before the trial. And in a lot of ways, it's very corroborative of what she testifies to in the trial. So without knowing what the jury relied on, I think it's dangerous to assume it was harmless error, because I think that when it's particularly given the detail that the statement goes into and how long it is, I think that the jury may have said, well, here she's saying she said these things before, they're consistent with what she's saying in trial, because to a large extent they are. There are some new things that come up during trial, but I think that the jury very well may have relied on what she said to the CPT investigator, and it is a pretty emotionally charged statement. And given that there are some discrepancies between the two statements, and there's some details that are left out, the jury, given the emotionally charged nature of it, and seeing a video, that may have glossed over.
Thank you.
And one other critical point that I haven't gotten into that I think is important for the court to consider is when JT is being asked to describe Mr. Delgado's body, and she initially says, I don't want to do that. And then, despite claiming to have seen him naked all these times, does not mention these large scars that he has from surgeries, does not mention that he only has one testicle because of testicular cancer, does not mention that he's uncircumcised, and that doesn't come up until the defense has disclosed a picture to the state, and apparently the state had asked if she knows the difference between the two. So those, I think, are pretty significant observations that the trial court overlooked in determining the reliability. Jumping ahead to issue 3, I know the state has argued and argued again today that the issue was waived. And again, going back to Figueroa, I would suggest because a material element is being left out, this is not something that can be waived. And Huckabee, where the court found there was a waiver, I believe it was the first DCA, it again was the situation where it was viable fetus versus unborn child, but in both situations, a crime was charged. I would suggest under Figueroa, when we have this situation where the information does not charge a crime, it's not something that can be waived, and it's fundamental error. I expect I'm probably at the end of my time. Thank you.
Thank you. Thank you both.
Thank you.
Right, next up, we've got Burton versus Tower Hill Select.